So calling to order, could we please have the land acknowledgement?
We would like to acknowledge
that we are here today
on the traditional territory
of the Mississaugas of the Credit First Nation.
Nous tenons à reconnaître que nous sommes sur le territoire traditionnel des Mississaugas de la Première Nation de Credit.
Thank you very much. We do have an agenda before us tonight with 3 staff reports along with our normal business. Could I have somebody move to approve the agenda unless there are any questions or changes?
Carrie will approve.
Thank you very much. Any declaration of conflicts of interest? Not seeing any hands raised, we will go ahead to the minutes. They were circulated. Have people had a chance to read them, and are there any questions about them? Wonderful. I will take everybody's silence to mean there is no problems. Can I have someone move to approve the minutes? Ms. Lawton, just nod your head delightfully and we'll...
I will approve the minutes.
Thank you very much. Takes us right into the bulk of the meeting. Staff reports. Ms. Lockyer, I will turn things over to you.
Thank you very much. And through you, Chair Marchand, pursuant to Ministry Directive number 5 at the regular meeting of the Board of Trustees on December 8, 2020, bylaws were presented which provide a foundation for effective meeting management and a structure for the decision-making processes for the trustees. Those board bylaws and related governance directives were approved at the June 16, 2021 board meeting. After applying the current bylaws for the past year and upon closer review of the current bylaws and also an environmental scan of some other procedural bylaws and best practices, there is some demonstrated need for and a recommendation for a few amendments, clarifications, and additions regarding the application and scope of the bylaws. In particular, there is the opportunity to apply the procedure bylaw to various committees, redefine some terminology, update committee terms of reference, which are referred to as governance directives in the current bylaws, update closed session recommendations, add a process for dealing with petitions, and include provisions for referral motions, etc., as outlined in the appendixes to the report. Appendix 1 is the current version of the bylaw showing the changes, and Appendix 2 is a clean version of the procedure bylaw. The procedure bylaw would be reviewed regularly to ensure that it is meeting the needs of the board and committees, as well as providing the necessary guidance for effective and efficient meeting management. Some of the key recommended amendments include having the rules apply to all committees subject to any legislative or regulatory priorities. For example, the rules will apply to SEAC, but where the rules differ from the regulation guiding SEAC, the regulation would prevail. Providing for regular reviews of the rules at least every term of the trustees to ensure that the rules are actually meeting the needs of the trustees and the public for accountable and transparent decision making. An organizational meeting at which members of committees will be selected shall happen after the inaugural and then 2 years later, such that committee membership is for a 2-year period rather than just a 1-year period. With annual changes in membership, there's often not a chance to really dig in and make a difference in the 1 year, but with a 2-year term, real advancement can be made. There will still be the requirement, as per the Education Act, for a chair and vice chair of the board to be elected at each year at the November board meeting. The trustee diversity self-identification form is embedded in the bylaw. Clarity around the authority of the director, including the authority to hire and reorganize structurally as required and to inform the board, has been included. Clarification of some parliamentary rules, such as the consequences of a present member not voting. Additional clarity around motions to reconsider decisions made in the same meeting or decisions made at a previous meeting. The addition of a framework around workshops or information sessions, inclusion of how to handle petitions, and inclusion of how the seating is determined in the board meeting room. There are a few other provisions that were added for clarity or to expand on existing rules for ease of application. With respect to next steps, it is the intention that these rules would be effective with the new term of office starting in November. On the June board meeting agenda, there will be a notice that it is the intention to review and approve the new rules at the September board meeting. The revised bylaws and a clean copy will be on the September board meeting agenda and posted publicly. Based on any comments that we receive here, we will also align the governance directives with the rules. One thing that I have noted from previous comments at other opportunities is that what we would usually call terms of reference are currently called governance directives. If it is the will of this committee, there could be a recommendation that the governance directives be changed to be referred to as terms of reference. The terms of reference would be approved by the board, but perhaps they could be reviewed by the specific committees first and have the committees provide any recommendations for change. This way, the terms of reference would be set out with the intention of the board, but with input from the committee members as well. We are planning an orientation session for trustees at the beginning of the new term, at which time we would provide training on the rules. And I also want to thank Trustee Lawton for pointing out the error on page 19 of 52 in the revised bylaw. As you can imagine, it's a formatting problem, and formatting as we change it is a challenge, and I missed the reference. So I'm going to go over the entire document again, just to be sure that all are caught when the numbering format is finalized with the appropriate changes. The reference in 4.1.1 is to section 3.7.1, and I'll fix that. So thank you for highlighting that and taking the time and attention to detail for that. Much appreciated, Trustee Lawton. So thank you all for your time and attention, and happy to address any questions.
Okay, I see a hand up from Trustee Green. Please go ahead.
Yes, thank you. I didn't have an opportunity to go through everything in detail, Kathleen, but Catherine. But one thing that for me as a trustee, I've been at the board this long. One of the things that I think crippled our board for a long time, and do not provide growth as in my opinion. I think that we need to maybe have in the bylaw is how long one person can stay the chair of the board. I think that's something that I personally look at some other board bylaws, and I think that even Hamilton, I think it's 2 years. That one you can chair. Basically, you can once if you chair 2 year consecutive, you can and nobody else wants a chair, then you can continue chairing. But if others want a chair, should able to chair, like the vice chair moving up to the chair position after that 2 years, and then later on, that individual can chair again. But I think that's something that we need to really look in, for the growth of other trustees that are on the board and who desire, may have the desire to chair the board with proper training.
Thank you, and for the question, and through you, Mr. Chair. The Education Act does require that the chair and vice chair be elected each year. If it is the will of the board to put parameters such as term limits around that, I don't think that there's anything in the legislation that prohibits that. But the legislation does provide that it is to be an annual election.
Through you, Mr. Chair. Yes, I know that much because I've gone through the Education Act and understand what the Education Act. But what I'm talking about is the parameter around how long one can stay the chair of the board. In this way, we're building people capacity because some people may not run again. So people may not get elected, and sometimes when you don't have that capacity build, you leave the board vulnerable. And I did my own research, and I saw that some other boards do have that parameter, I would like to see that in ours. But again, that is up to my colleagues to decide. Thank you.
Thank you.
Thank you. Trustee McDonald, you have a question?
Thank you. I have two. On page 51 of 55, when you had removed, you said the chair of the board in consultation with the director or designate, and then it's removed an agenda review committee will consider all delegation requests. I was just wondering what would happen if, let's say we have a situation where somebody wants to delegate the board and, for whatever reason, let's say the chair decides that I don't like that those people that are delegating, I don't want to hear from those people, or I'm tired of hearing. Like how can you guard against if it's just left up to those two individuals, that the community is not shut out like we had seen previously?
Thank you for the question. And there is a directive, a governance directive on delegations, and the consultation between the chair and the director is about where to direct the delegate, not whether the delegate can come or not. So there are very clear parameters for delegations. The only time that a delegation is not sort of accepted is if it's outside, that they're asking to delegate on something that is outside the parameters or the purview of the board. Okay. And then there's no authority to hear the delegation. So the delegation request is reviewed to see if it should go to committee of the whole, or should it go to the audit committee, should it go to the physical planning and finance and building committee, just to determine where the delegation should be best directed.
Okay, thank you. And I have another question through you, Chair. So given that we will at some point no longer be under supervision, right? So okay, let's say we have a new board, and the board people that come back, or some people may return and want to say reclaim the board or the way things were before, that type of thing. How can we guard against that? These, for example, our new bylaws just can't be tossed out and replaced with the old ones, the different policies that are in place. Because let's say that person comes in and they have enough support from members to say, okay, we want to vote to get rid of a policy, right? And let's say we get legal advice that supports it, because people can get legal advice to support what they want to do, and that comes forward. Would you be so I just want to know, like, can you be sort of the judge and jury of the procedures, or how does that work in terms of ensuring that we are doing things that are legal and following, even if the will of the majority wants to do something that is not like in keeping with bylaws, and even if it's written in a bylaw, somebody could say, well, we're just going to support the chair's ruling. They don't care what the bylaw says. How do we prevent about that situation if it should occur? Can you prevent it?
Thank you for the question, and through you, Mr. Chair. The rules of procedure are a bylaw of the board. And in order to change the bylaw, and so they are approved by vote, in order to change the bylaw, if it is within the same term of office, would require a 2/3 majority vote. The will of the trustees, the will of the board, is what determines and sets policy and direction. And that is the system of governance that is set up with the trustees. So there isn't a mechanism outside of the elected officials to say, no, the elected officials are not permitted to do what they're doing. The exception to that would be if there was a court challenge to a motion that was passed. And it is possible to challenge resolutions or decisions that are made through a court process, but there is not a process to sort of overturn a trustee decision by administration.
Okay, so if the trustees have done something that is, let's say, goes against the legal, like, or the human rights code, let's say, right? Then there's nothing that administration can do. So like, somebody'd have to legally challenge it again, or like, how does that work?
So through you, Mr. Chair, a motion would be out of order if it is illegal, which means that even if they tried to pass the motion and it was an actual illegal motion, then it would have no force and effect.
Okay, so even if, let's say that they say, okay, they challenge the chair and the trustee supports the chair's decision, if it's illegal or if it goes against the bylaws, then it can't come into fruition?
I think that I caution the answer in this because it could be open to interpretation about what is actually legal, what you're referring to. And in an abstract, that's a very difficult question to answer because we wouldn't know what the circumstances are. So something like the Board of Trustees purported to change the Constitution of Canada. That would be ultra vires. It would be outside of the scope of the trustees, and it would have no force and effect. Okay. When there's decisions made that are open to more clear interpretation, or unclear rather interpretation, there could be some argument about the enforceability. That's when the advice of administration and legal would come to bear, and if it is determined that there is an objection to it, there is the court proceedings available.
Okay, so for the advice, last question through you, Chair. So for advice, we go to, so you are our advice person then?
Through you, Mr. Chair, I'm General Counsel and Governance Officer, so I'm probably your first stop for advice, yes.
Okay, thank you very much. That makes my heart much easier and lighter. Thank you.
Thank you.
Are you sure you're done, Trustee McDonald? Okay.
Yes, through you, Chair, I'm done. Thank you.
Thank you. Trustee Andrews?
Thank you, through you, Chair Marchant. I was trying to answer my own question by going through the paperwork again while I was waiting, and I didn't. So, Catherine, you mentioned that on the committees that the trustees would be in those positions for 2 years, you know, for consistency and, you know, and getting the job done. So what about the chairs of those committees? So could the chair rotate? So somebody could chair it 1 year and then another person on the committee could be chair the second year, or is that position held for the 2 years of the committee?
Thank you for the question. That's a very good question. The committee membership determines the chair of the committee, the committee, and that can be done annually.
Okay.
Depending on the terms of reference. Yes, exactly. Okay. But the membership in the committees is for the 2-year period.
Okay, great.
That is a change from what we currently do for sure, which is the 1-year term.
Okay, thank you.
Trustee McDonald, I see your hand is still up. Nope. Okay, thank you.
It was a really dear hand.
Catherine, I just had one question, sort of towards as a clarification, just toward Trustee Green's consideration about term limits. Did part of your jurisdictional stand sort of look at that? And if so, what sort of best practice would be out there? I'd be concerned where you've got a board of 11 people, all of whom are comfortable with the current structure, and one person who wasn't. And if you've got something that says, you know, no one, you know, can that one person automatically, you know, override it? Just in terms of how that might be set up elsewhere and how that works.
Thank you for the question, and through you, Mr. Chair. The scans that I did not contain any term limits on chair or vice chair, but I can check further. References, particularly Hamilton. I believe that Trustee Green indicated Hamilton had a term limit on the chair and vice chair. I can check that, but I did not see in my environmental scan any other term limits on chair and vice chair positions.
Okay, thank you, Lockyer. Perhaps if that information could be put forward with this, so that when trustees see it as a group of the whole, they could know whether or not to make a motion to make that amendment.
Thank you.
If that would satisfy Trustee Green.
That's fine with me, sir.
Okay, thank you. And we will turn it back to you for your next presentation. Thank you.
Thank you very much. Did just before we start the second one, did you want to bring a motion to recommend that the amendments go to the September meeting?
Yes, that I think would be a great motion to bring forward.
Okay. Thank you.
Lawton, can you so move that?
Trustee Lawton actually isn't a member on the committee.
Oh, Miss
I can move it.
Thank you very much.
Thank you, Trustee Andrews.
No problem.
And on to item 6.2, the Policy Management Program. Thank you, and through you, Mr. Chair. Pursuant to Ministry Directive 5, there is a recommendation that a policy development and review process be developed that incorporates specific methods to obtain input from the educational community to inform the board's policy decisions. A policy is a statement of intent and is typically implemented by procedures. Policies assist with decision-making and provide frameworks, regulation, and guide actions. Policies can usually be tested and measured through compliance or particulars set out in the policy itself. Policies are the vehicle that the board uses to address concerns or initiate ideas or provide solutions to effectively deliver education to the community, which is the explicit goal of the board. A policy management program is a deliberate set of guidelines, rules, and decisions to achieve desired outcomes. Historically, policies have been developed at the board on an ad hoc basis as the need arose, either through community concern, legislative requirement, or staff or trustee initiative. A systematic policy management program allows for the coordinated approach for policies which will, together, achieve the outcomes for the board. A policy management program will provide the framework for consistent, comprehensive, current, and compliant policies for the organization. There are a variety of components to a policy management program. A few of them include a naming and numbering convention for easy access and reference, as well as a review timetable to ensure policies are kept current. A key to a good policy management program is a policy on policies. It is important that policies are developed within a framework which will ensure the consistent approach to policies. A draft of the policy development and review framework is attached to the report for your comment. We will be doing further consultation on the policy with senior leadership to ensure that the framework meets the needs of leadership. However, we wanted to ensure that the framework meets your needs as trustees, who are the actual decision makers for the policies first. The policy sets out the steps from development to approval, and then communication and awareness of the policies as well. Once the policy is approved, it will be implemented by including a naming and numbering convention, review and update existing policies, identify procedures flowing from policies, identify gaps in policies, and develop and implement policies to fill those gaps. This is a significant piece of foundational work, but necessary for accountable and transparent governance. I'm happy to take any questions and comments on either the policy management program itself or on the draft policy.
Okay, thank you. Do we have any questions or concerns and/or comments? I think you've nailed this one then, Ms. Lockyer. I don't see any concerns or questions, so please, thank you. I found it quite comprehensive myself.
Thank you very much.
Trustee Crocker, can we move this forward? So what do you need from us on this one, Ms. Lockyer?
Happily.
Thank you. All right, which I guess brings us to your third one, which is student trustee policies.
Thank you very much. And for this, I'd like to pass it over to LaShawn Murray, who is our policy analyst that we've hired at the board to help us with that policy management program. And so I thought this was a good opportunity for you to meet LaShawn. And so she's going to be presenting the student trustee policy.
Okay, thank you for joining us, LaShawn, and Ms. Murray, it's all yours.
Thank you, through you, Chair, and great to see everyone again. Different role for me, moving from research to legal, but glad to be here and to be supporting this work. And so for the student trustee policy, so following the student trustee election, we review the policy to ensure compliance with the Education Act and Ontario Regulation 707. And some key amendments that are outlined within the policy from the beginning, starting with eligibility criteria. So going back to the legislation and referencing directly that students must be in the senior division of a high school, as opposed to having sort of the 16-year age range. Providing more clarity on the method of consent from a parent or a guardian, so being really explicit with it being written consent. Eliminating the ambiguity that comes around the previous last bullet point around strong academic standing, good leadership skills, good communication skills. It's unclear how that is measured and to determine if a student is qualified to run for election. So sort of removing that language. We also added in the date for the term of office running from August to July, but maintaining the expectations for students to only serve during the school year. Further related to the legislation, we added in the clause that student trustees cannot move a motion as per legislation, but sort of the process around having that documented. For this current election year, we had an April election date within the legislation that moves back to February, and so clarifying that February election date with the 30-day reporting to the ministry moving forward. And towards the end of the document, to be in line with the trustee expense policy that was recommended for approval earlier, increasing the allocation for professional development from $1,500 to up to $2,500 as listed within the trustee expense policy. And so our next steps, we've been working in collaboration with the school support team within Caring and Safe Schools. And so continuing that collaboration to make the appropriate changes within the student trustees election guide, which includes providing the additional details on campaigning during the election period. Thank you.
Thank you, LaShawn. Do we have any questions for LaShawn? Okay, I do have one question for LaShawn, and perhaps we'll go first then. LaShawn, I noticed it says you need parental or guardian permission of written permission of a guardian for anyone under the age of 18, where we could have emancipated 16-year-olds within our board who are attending our schools. Are we excluding them, or how would we include them in the eligibility? And what was the legal requirement for written permission of a parent?
And thank you for the question, and thank you for giving us a heads up. We will be getting that question. LaShawn and I did talk about that. It's a great observation, and we're going to amend the policy so that the motion coming out of this this committee could be to recommend with the amendment to say under 18 or under 16 if removed from parental control. And as for why we have the written consent, while the sections dealing with student trustees in the Education Act and in the regulation don't talk about parental consent, there are many examples throughout the Education Act requiring parental consent. In particular, two instances in particular. One is that pursuant to the policy, this could be the experience of being a student trustee could be a credit course. So they could be actually earning credit while they are acting as student trustee. That's considered alternate programming, which does require parental consent under the Education Act. Second, parents are responsible for attendance. And with that responsibility, it's usual for parents to have to consent for any absences or for additional school programming such as field trips or conferences or anything like that. So as this role does include off-school meetings and conferences, obtaining the consent at the beginning of the term helps with that for the student trustees to attend to their duties, such as you're going to hear at the June meeting about the current student trustees' experience at the OPSPA conference in Ottawa. And, we have parental consent for that. So while you're quite correct, Chair Marchant, that it's not a requirement in the particular sections, it is a requirement throughout the Act, and we thought it was best to be consistent with that and retain the parental consent required for the role.
Okay, thank you. I think if they were, I think the first part around the other forms of instruction that would require parental consent, they would have to give give parental consent for them to do that in credit form, regardless of whether or not they were a student trustee. So I think that's sort of a bit of a duplication of process. I also wonder if, just giving consent to be a student trustee, of course, doesn't give blanket consent for them to participate in trips to Ottawa per se. So I think those would be individual as well. So I'm not sure the value of adding an extra consent in here, seeing as you've mentioned, it is consistent in other areas where there is specific risk to students around attendance to outside functions or other things. I guess other than the fact that being a student trustee does require their attendance at board meetings and such after hours. So I think with the amendment, I'm probably happy with that. I don't see it as a huge barrier for most of our students. Any other questions or comments or concerns? No? Well, thank you. In that case, who else do we have out there? If any of the trustees would like to move to take this forward. Ms. Andrew? Yep, thank you, Carrie. I'll take that hand. Thank you.
My pleasure.
Ms. Locker, do you have anything else you would like to add before we move on?
No, thank you very much for attending, and I think that is my list for this evening. Thank you.
Move to step 7. Do we have any trustee motions for consideration? I don't think any from previous meetings. No. Do you have any for discussions at future meetings? No, not seeing anyone. Then I will move for adjournment. Trustee Crocker?
I will move, we adjourn.
Okay, well, thank you everybody for your attendance tonight. That was quick and easy, and Ms. Lockie's presentations are to the point, very informative. The way you put the information before us made it very easy to read it and scan it beforehand. So thank you very much for that.
Thank you.
Okay, thank you everyone, and we'll see you.
Thank you.
Thank you, everybody. Good night.